Hey everybody, it's Paul from Cary Estate Planning back with another video as part of our 2020 challenge. And today I wanted to talk about disinheriting someone in your will and whether or not your family has the ability to override your wishes. So generally, there are certain default statutory rights that people can have in the estate of a deceased loved one. Those usually fall to spouses and minor kids, and they can be limited or significant depending on what your intentions are. So generally, minor kids have the ability to seek what's called a year's allowance, but it's usually a nominal amount, just a few $1,000s. That's only really until they're completing school, really reaching the age of majority, and it's usually insignificant when it comes to the overall value of someone's estate. The spouse, however, has the ability to take the first $60,000 of personal property under the year's allowance statute for spouses, and then up to 1/2 of the net worth of the deceased spouse. So when we talk about disinheriting a spouse, there's limitations there. Adult children, though, you can do whatever you want. So of course, the most important piece is getting a legal, valid will in place and aligning your beneficiary designations with your intentions in the will to remove a child or another family member from receiving an interest in your estate. The big thing there is you always want to make sure things are done appropriately to eliminate the risk of any potential lawsuits or caveats based on there being some improprieties or things that didn't go the way they were supposed to according to North Carolina law. So obviously having witnesses and a notary, attesting to the fact that you're competent and understand the significance of your actions. We usually like to put some sort of declaration in the will that it is your intention and you're doing it, with full understanding of ramifications to disinherit that child or that family member. But generally, as long as you had capacity, understood the significance of your action, we're not under any undue influence or duress, and the will was executed with proper formalities, your wishes will be upheld. And of course, another significant aspect of that is that your will does not control most of your wealth succession if there are beneficiary designations named. So we want to make sure that all of your beneficiary designations are current, removing that family member from your beneficiary designations across the board through all financial assets to make sure that your will and your financial circumstances are consistent in removing that person from receiving a benefit. The other piece obviously is deciding who then would receive the share that would have gone to that family member. And of course you can include whoever you'd like. You could redistribute that share among the other remaining beneficiaries. You could add a charitable beneficiary. You can really do whatever you'd like. It's just a matter of getting clear on what that is and effectuating it. This is Paul from Cary Estate Planning.